And we told you about that conversation. It's about the ongoing Capital Bank and shareholders case as brought to the courts by the Attorney General, of course, representing the government of Ghana. But in the meantime, we have to let you in on what you should be expecting. And let's get to some quick facts on the because we have first accused person, William Atuasian. He was the majority shareholder of Capital Bank Limited, a wholly Ghanaian bank which previously operated as microfinance. And then when you move on also, the second accused person is Tete Nete, was the managing director of MC Management Service. That's a company established by the first accused person purposefully for the promotion of the incorporation of Sovereign Bank, another brainchild of the first accused. And according to what the facts of the case are, this is how it's unraveling. The third accused person, Fitzgerald Odonko, was the managing director of Capital Bank, and this was between the years 2015 and 2017. Now, if we move on, we also get to know about what really the facts of the case are, indicating that the fourth accused person is Kate Kwote Papafio, a businesswoman and chief executive officer of Railroad Cables Ghana Limited. And you look at what the issues are. It says that between 2015 and November 2016, pursuant to an application by Capital Bank, the Bank of Ghana provided a total sum, and look, we've been saying this all over, 620 million Ghana cedis, and this was supposed to be used as liquidity support to Capital Bank to enable it to meet its capital adequacy ratio and to enable it to service its maturing debt obligations. But as the case is in October 2015, the first accused person, according to the facts of the case, as brought to the court by the Attorney General, aided by the third accused person, caused a transfer of a sum of some 120 million Ghana cedis of the liquidity support that was from the Bank of Ghana to All-Time Capital Investment Management and Advisory Firm. And if you move on, at the instance of the first, second, and third accused persons, 100 million Ghana cedis of the transferred 120 million Ghana cedis, which had been transferred to All-Time Capital, was further transferred to MC Management Services. So the Attorney General is trying to do a certain linkage here, weaving the story intricately and trying to bring out a certain web, allegedly, of some actions. Because while 20 million of the amount of 120 million was then transferred to Pronto Construction and Supplies Limited, just known, in corporate terms as Pronto Construction. And at the instance of the first and third accused persons, 65 million out of the liquidity support from the Bank of Ghana of some 620 million was transferred to Nordia Capital Limited, described just as an investment bank. And just think about it. Of the amount of some 65 million, the first accused person, and that will be Atuasian, aided by the third accused person, caused 30 million Ghana cedis to be transferred to MC Management Services, which was represented to the Bank of Ghana as an additional initial capital of Sovereign Bank by the second accused person. And according to this, just, I don't know what you want to make of it. Whether this is financial engineering or whatever it is, the Attorney General is also saying, with the aid of the third accused person, the remaining 35 million Ghana cedi of the 65 million was paid into a fidelity account with the name Britlin Services. And this Britlin Services is a company also established by the first accused person. At the request of the first accused person, the amount of some 35 million Ghana cedis which was transferred into the account of the Britlin company, was subsequently transferred to Capital Africa Group. And this Capital Africa Group, a company it is, also owned by the first accused person. Now, the total amount of 130 million, which was represented as the initial capital of the Sovereign Bank, was eventually channeled by the first and second accused persons into Capital Africa Group, the first accused person's company. and this one was done, this whole transaction was without the bank charges. The monies transferred into Capital Africa Group was eventually dissipated by the first and second accused person. We're not the ones saying it. These are the facts of the case as put before the courts by the government of Ghana, represented by the Attorney General. Now, between June 2015 and October 2016, the first accused person, with the support of the third accused person, appropriated a total of some 27 million Ghana cedis of the liquidity support, which was conveyed in jute bags to the first accused person and purportedly used as payment for business promotion. In June 2017, in furtherance of the conversion of the portions of the liquidity support of some 620 million, which was coming from the Bank of Ghana, the first accused person caused the sum of some 100 million to be paid into a capital bank account held by the managing director of the three companies, Maripoma Enterprise Limited, we had Hardwick Limited, and also we had Volta Impex Enterprise as well. And if you go further, the Attorney General is saying that the 100 million was to be used by the managing director of the three companies as payment for 30% shares in Capital Bank. Now, the first accused person, according to the facts of the case, cost 70 million Ghana cedis out of the 100 million Ghana cedis that was transferred as the 30% shares that had been previously paid into the managing director's account at Capital Bank to be transferred to the fourth accused person's account with Cowbank Limited. Now, the first and second and fourth accused persons then subsequently caused the amount of the 70 million Ghana cedis in the Cowbank account of the fourth accused person to be further transferred into a personal account of that same fourth accused person. And this one was, according to the Attorney General, open a Capital Bank to receive the amount. Sometime in 2017, after Capital Bank had gone into receivership, the fourth accused person, even though fully aware that Capital Bank had gone into liquidation, attempted to withdraw the whole amount of 70 million Ghana cedis, which had been lodged in her personal account with Capital Bank, but was, however, prevented from doing so by the receivers. Now, if we take a concrete look at some of these indicators, it also gives us what the whole story also needs to be. And you look at what the stories are, we also will get to know what the facts of the case are. Because if you look at the whole implementation process itself, it also gives you what we need to know by way of this. We'll be speaking to Mr. Martin Pebu. And Mr. Martin Pebu is a legal practitioner. He will also get to tell us what we need to know about the things that have transpired so far from the event of yesterday at the courts. And then we'll bring you the story that was filed by Joseph Akable. As we get in touch with Mr. Martin Pebu, would want to bring you that wrap up by Joseph Akable, and then we'll come back and give you some more gist as the contributions come in from Mr. Martin Pebu. Do stay on.
Attorney General Gloria Kufuor on Tuesday presented the facts of the case to an Accra High Court presided over by Justice Eric Che Bafo. She told the court that liquidity support amounting to 620 million cedis handed by the Bank of Ghana to revive Capital Bank was appropriated and transferred to various companies owned by Mr. Essien. Defense lawyer Dr. Dominic Ayene, however, says the case filed by the state is strange.
It is very, very clear that you cannot steal somebody's property with their consent. Even from a common sense point of view, it is impossible for you to accuse me of stealing when you have given me the property yourself, willingly and voluntarily. Of course, if I said things to you that represented fraudulent misrepresentations, in that case you can say that I have defrauded you. But where I have taken your property with your own consent, I cannot be accused of stealing.
AG Gloria Kufuor, however, disagrees.
I will briefly say that the monies that were given to Capital Bank were given to Capital Bank, neither to Essel, neither to Fitzgerald Odonko, neither to Nettie, neither to the lady accused person, Kwoti Papafio. The money, as the lawyers for the defense themselves said, was given to Capital Bank. Basic principle in law is that a company is a separate personality from the individuals. So if money is given to a bank, and mind you, for a specific purpose, and then individuals, be it that they have any interest in the bank, they are still separate and apart from the bank. If they use it differently, in a manner which is not consistent with the purpose for which the bank advanced the money, certainly there must be a problem.
She has revealed a special investigative team is looking into other collapsed banks.
The investigations are going on. What it is that for the sake of expedition, my office is very concerned that these matters be dealt with expeditiously because of the public interest, because these are monies of the state which has been advanced to the banks. And so a special investigative team dedicated to investigating the bank cases are working on them. And you can imagine it's not a simple stealing matter. You caught somebody with a goat, but we are talking about bank transactions over a period. You can imagine the number of documents that you have to review.
William Atu Essien, Dr. Tetenete, and Fitzgerald Donko were granted bail to the tune of 200 million cedis each. They are each to provide 4 sureties. Kate Korte Papafio was also granted bail to the tune of 75 million cedis.
Look, we will make sure we touch base with Martin Kpebu, even not on this segment, on subsequent programming, and because he's a regular contributor, legal practitioner, will help us with all we need to look forward to when the next date for the court case comes up. But now you do know what the facts of the case are. We'll follow through, make sure we give you pointers right here on the show.